Get ready for the dictation. Start. According to the petitioners, they were entitled to employment in the government service on non-teaching posts. They could not have been appointed as panchayat teacher under the rules of 2006. Reliance was placed on paragraph 17 of the memo of the letters patent appeal number 697 of 2005 preferred by the state government against the order dated 6th April 2005 passed in the above referred CWJC number 14391 of 2004. In the said paragraph 17, the state government had committed the stand of the respondents in the present case was not to deny the appointment of the defendants on any other equivalent post, but precisely not on the post of assistant teacher, as they were untrained. The petition was contested by the state government. According to the state government, the petitioners not being trained, they had no right to appointment as assistant teacher in the government schools. All that they could claim was the compassionate employment. In the discretion of the state government had appointed the petitioners as panchayat teacher on available vacancies. The appointment of the petitioners was in consonance with Rule 10 of the Rules of 2006. The petitioners, having accepted such appointment, the challenge to the said appointment was not tenable. The learned single judge, by the impugned judgment and order, held that the recommendation made by the committee to appoint the petitioners on non-teaching class 3rd posts in the government service was binding to the appellants. Consequently, the learned single judge has issued direction to the appellants to shift the petitioners within 1 month from the date of receipt/production of a copy of this order and adjust them against any non-teaching class 3rd posts in any of the offices of the government in the district as may be available now. Since the petitioners had joined pursuant to the appointment letter issued to them between 2nd May to 5th May 2005, after the orders of the learned single judge, they shall also be entitled for continuity of their service so far as seniority and other service conditions are concerned, except actual payment of differential of salary, which they may be found notionally entitled to. Feeling aggrieved, the state has preferred this appeal. Learned advocate Mr. Manoj Priyadarshi has appeared for the appellants. He has submitted that the impugned judgment and order of the learned single judge is contrary to the full bench decision of this court in the matter of the state of Bihar and others versus Rajiv Ranvijay Kumar 2010 3 PLJR 294. Mr. Priyadarshi has submitted that the full bench of this court has clearly stipulated that the dependents of the deceased government servants have no right to preference in the matter of appointment. They cannot claim appointment on class 3rd posts in government service as a matter of right. In view of Rule 10 of the Rules of 2006, they can be appointed as panchayat teacher under the said rules. Mr. Priyadarshi has submitted that the learned single judge has appreciated the principle enunciated by the full bench but has failed to implement the same. Mr. Priyadarshi has also submitted that the appointment of the petitioners as panchayat teacher under Rule 10 of the Rules of 2006 is legal. The petitioners having accepted such appointment, the same is binding to the petitioners. The appeal is contested by the petitioners. Learned Counsel Mr. Vinod Kumar Kant has appeared for the petitioners, he has submitted that the petitioners do not ask for compassionate employment on class 3rd posts in government service as a matter of right. The claim is based on the solemn statement made by the state government and the direction issued by the division bench of this court. Mr. Vinod Kumar Kant has submitted that the petitioners do agree that they are not qualified to hold the post of teacher in government schools and that they have no right to employment as teacher in the government schools. But in the aforesaid fact situation, the petitioners have a right to employment on class 3rd posts under the state government. Employment as panchayat teacher under the rules of 2006 is not a service under the state government appointment to which the petitioners are entitled. Learned advocate Mr. Priyadarshi has extensively read the full bench judgment of this court in the matter of Rajiv Ranvijay Kumar. There is no gainsaying that the full bench of this court has, in no uncertain words, held that the untrained persons cannot claim right to appointment as assistant teacher in government schools on compassionate ground. The bench has also held that Rule 10 of the Rules of 2006 does permit the state government to make appointment of assistant teachers on compassionate ground. However, the question before us is whether the petitioners have to be appointed as panchayat teachers under Rule 10 of the Rules of 2006. Does the said Rule 10 enjoin the state government to make appointment of petitioners as panchayat teacher on compassionate ground? Stop.